Hello, everyone. Today, our group will be presenting Seminar Two's topic, which is the legal aspects of corporate finance, particularly in a South African context. An overview of the seminar and what we will be discussing is shown here. The first discusses two legal frameworks that are used in the country. We will then move on to the makeup, roles, duties, and responsibilities of both auditors and shareholders. And the last includes additional topics that Group 2 created from an interview with Darren Subramaniam, who specializes in business law. Before we begin, why is it important to look at the legal aspects of corporate finance? For the what question, it aims to simplify the structured finance process and explain the legal implications as well as the tax considerations. And the why is because legal rules underpin stable financial markets. Also, well-functioning financial markets require not only that these legal rules exist, but that they operate in an environment where they are effective. That's why there are many regulatory frameworks that are tailored to certain needs, such as the JSE Issuer Regulation Guide, that is specifically for those companies that are listed on the index.
What is the Companies Act 71 of 2008? The Companies Act number 71 of 2008 is a primary legislative framework under South African law that companies have built in or registered under to help govern their policies. This act allows for transparency among companies, increases quality of corporate governance, and ensures that rights and obligations of different parties are met, and also ensures that legal redress for shareholders and third parties is considered for companies and their board of directors. What are some features of the Act? It has been modernized and brought into line with international best practices. This applies in particular to public companies, communications, and corporate governance. It has also been harmonized with other South African legislation, such as Promotion of Access to Information Act and the Electronic Communications and Transactions Act. What is the purpose of the Act? The Act's principal goal is to encourage corporation law implementation that complies with the Constitution's Bill of Rights. It also promotes the development of the South African economy by encouraging entrepreneurship and business efficiency, amongst allowing for greater flexibility and simplicity in business establishment and maintenance. What are some of the implications of the Act on businesses? Under the Act, smaller businesses will no longer automatically be subject to strict financial reporting and auditing requirements. This allows companies with characteristics very similar to those of closed corporations to be formed, meaning there is no longer a need for closed corporations. And existing closed corporations will be treated as follows. They will exist indefinitely, and they will be treated as private companies, and the Closed Corporations Act will be brought into line with legislations on private companies.
We now look at the Issuer Regulations Guide. This comprises of the Company Act, the Financial Markets Act, as well as the requirement for JSE listings. The Issuer Regulation Division is the requirements that apply to companies seeking new or existing listings. Applicants are required to present a pre-listing statement containing detailed disclosures. The protection of investors is very important for JSE, and this is ensured by the maintenance of minimum standards, as well as ensuring that information that is relevant is publicized. An important component as well is company role players. Any JSE listing requires the cooperation of key company role players. This could be the auditors, the listing sponsors, or the board of directors of the applicants. Other role players, however, vary from industry to industry.
The Market Regulation Division is responsible for overseeing trading in markets operated by the JSE. Its core objective is to identify any potential market abuse in the form of insider trading or market manipulation to ensure that markets are efficient and fair at all times. The JSE has market surveillance systems in place to detect any misconduct. Misconduct of any kind is referred to the FINA7CR. The Financial Sector Conduct Authority serves the purpose of protecting customers against any unfair treatment by financial firms. Under the Financial Market Act, the FINA7CR is mandated with certain legislative powers to ensure that the financial markets in SA trade in an ethical manner. Breaching of any financial laws makes individuals or firms liable to face administrative penalties, or in worst case scenarios, criminal penalties.
Companies and Intellectual Property Commission. The Companies and Intellectual Property Commission was created by the Companies Act to serve as a state organ within the public administration, but not as a government agency. Entities that can be registered under the Commission include companies, cooperatives, and intellectual property rights to disclose their information under the Act. Takeover Regulation Panel. This panel was once again established by the Companies Act to regulate affected transactions or offers. It enables shareholders to make informed decisions and to obtain the necessary advice in respect of proposed offers. The reason for needing to regulate transactions is to protect minority shareholders by ensuring that during transactions or offers, they have access to certain information. I will also be presenting on what a shareholder is and the duties and responsibilities that come with it. A shareholder is an individual that has a personal stake in a company, and they must own at least one share of the company's equity and usually provide capital in setting up of the company. Being a shareholder not only includes receiving a dividend of a company's profits, but also includes determining the extent of power and influence board of directors can have on the company. They are not liable for acts or omissions of the company. Duties of a shareholder. Shareholders act in favor of the company's best interests. Hence, it is their duty to hire directors who will also make decisions favoring the company's interests. However, this isn't a fiduciary duty. Some of their duties include approval to financial statements and company frameworks. There are certain decisions the board of directors can only make with the permission of shareholders. The issuers regulation in 2021 stated that these approvals include major acquisitions and mergers, which make use of company funds in repurchasing of company shares. Shareholders should not act in a way that could jeopardize a company's interests. Responsibilities of shareholders. There are many obligations attached to the rights and power that a shareholder has. As a result, shareholders play a significant role in the operations of a business. An important responsibility is attending annual general meetings, as this is a space where they can successfully exercise their rights. They need to apply the corporate governance code together with working as a regulator with the management of their company. This is required as a preventative measure in case of disasters, as well as to protect their assets.
I will be talking to you about auditors and the responsibilities and duties that come with them. First of all, an auditor is an authorized individual who reviews and verifies the accuracy of financial records. They ensure that the company complies with tax laws as well as that the company's activities are transparent. From the slide, you can see that auditors need to maintain contact with regulators, such as shareholders, who can rely on them to be transparent with company activities. They also need to form an opinion on the company's financial records. It is important for auditors to act with integrity and to exercise their responsibilities. An auditor's responsibilities is defined under Section 2271A of the Companies Act. They are required to review and assess financial records for any errors. They are responsible for making an opinion on the accuracy and fair representation in their audit of the firm's financial situation. Their reviews include an evaluation of internal controls and accounting systems. Auditors need to take action if they discover fraud or inaccuracy of their accounting records by notifying the correct authorities. If these responsibilities are not fulfilled, auditors can be held accountable for damages relating to the firm and or its employees if their opinions are contradictory to any discoveries made. Their duties. First and foremost, it is an auditor's duty to perform an audit. They are required to form an opinion whether it is negative or positive. The auditor needs to make inquiries where necessary to ensure loans and advances are suitably secured. It is important to guarantee that any transactions made are in favor of the company's interests. In addition to this, they need to report a fraud found, comply with auditing standards, and follow the accounting code of ethics and professional conduct.
We now find ourselves at the important legal elements for corporate finance practitioners. Finance and law are closely interrelated, and therefore it is imperative for financial practitioners to always be compliant with these laws in order to avoid unnecessary, unwanted, and costly legal penalties. Financial practitioners should always act in accordance with the Financial Sector Conduct Authority, also known as the FSCA, which has since taken over from the Financial Services Board on the 1st of April 2018. The three elements we'll be discussing are investments, financing, and dividends. Investments in South Africa are governed by the Constitution under the Protection of Investment Act number 22 of 2015. The Act sets the tone for how investment-related matters are to be handled, as well as stipulating the rights and obligations of each related party. Financing refers to the process of how a business secures funds to fund its operation. Funding may be in the form of either debt or equity, each with its own unique repayment plan. Debt is usually the cheaper of the two, however, proves to be the more difficult to obtain, especially for small companies. Dividends are a share of a profit a company allocates towards its shareholders, depending on the dividend agreement. Dividends may be paid out throughout any time of the year and are most commonly paid out on a quarterly, biannually, or annual basis. There are various types of dividends a shareholder may receive. Most of these elements are regulated in one way or another, and practitioners should always be aware of the regulations at hand.
We now explore the role of trade unions in corporate finance. Trade unions bridge the gap between employers and employees by cultivating an open line of clear communication and representing their members in negotiations when needed. Their main goal is to protect employees and ensure that Sector 36.1 is adhered to by firms. We can see since the introduction of trade unions an overall improvement in social welfare, working conditions, as well as the ability to maintain minimum wage. Trade unions affect corporate finance in both a positive and negative light, with one of their largest positive contributions being the ability to maintain company image. Trade unions achieve this by swiftly and efficiently solving problems as they arise, but specifically in isolation, thus keeping company image out of a negative limelight. A study conducted in 2016 by Tash Shah found that in highly unionized industries, firms tend to increase their dividends payments as a way of protecting their internal resources from trade union capture. However, we associate an increase in dividend payments with greater profitability and high cumulative returns. Thus, investors respond positively. A negative connotation was found, however, in a study done in 2017 by Mark Stewart, indicating that trade unions are associated with low profitability and a decrease in financial performance. A pattern can be identified, especially in the long run, with trade unions' wins negatively affecting the market value of a firm and its stability. Significant costs are also incurred by firms due to trade unions, concluding that the presence of trade unions cannot be understated.
Now, speaking about the policies designed to alleviate the risks of the post-financial crisis. During the recession, almost 1 million South Africans lost their jobs, and to put this into a global perspective, that's 1 million out of 34 million job losses worldwide. Although South African banks were not directly exposed to the mortgage market in the US, banks were damaged indirectly by the collapse in the share prices. During a recession, it's important for banks, specifically the Reserve Bank, to make monetary decisions that affect the nation. The South African Reserve Bank implemented several policies in response to the crisis. The following information is from the National Treasury document of 2011. Leading into the financial crisis, there was a rapid growth in credit extension, and this created risk to the inflation targets. As a countercyclical monetary policy, the Reserve Bank gradually raised the repo rate from 7% in 2005 to 12% by mid-2008. Then, as the financial crisis unfolded, the Reserve Bank reduced rates rapidly, which cushioned the domestic economy from adverse global conditions. In the aftermath of the financial crisis, there was a renewed focus on managing system-wide risk across the entire financial sector, which became known as a macroprudential approach to regulation. In December 2009, the Basel Committee proposed a set of bank supervision reforms that required banks to hold enough high-quality liquidity assets to see them through both a solvency and a funding crisis. The proposals took into account the lessons of the crisis, particularly the rapid spread of contagion from one bank to another. In more recent years, the Financial Sector Regulation Act of 2017 was implemented, which aims to help prevent the financial sector from collapsing.
A hostile takeover occurs when a company or person attempts to take over another company against the wishes of the target company's management. This can be achieved by the acquiring company going to the target shareholder or fighting to replace their management. A hostile bid offer, while unusual, can also be made. Hostile bids are permitted in South Africa, however, a general offer is needed before it can be made hostile. The Companies Act No. 71, as previously mentioned, regulates all takeovers, public mergers, and acquisitions in South Africa. The provisions governing takeovers are called takeover regulations. While target companies are able to use certain defense strategies, such as the poison pill, the takeover regulations place their board of directors in the driver's seat for the practical implementation of offers should they proceed. The board has the right to receive, announce, and publish a response circular to bidders after showing its opinion on the substance and merit of hostile offers. Here, takeover regulations allow the target to challenge the substance and process the hostile bid with submissions to the takeover regulation panel. Another essential statute is the Financial Markets Act No. 19, which includes the South Africa insider trading and market abuse legislation. With this, regulated companies are subject to takeover regulations following affected transactions. A contradiction arises that if 10% of the issued securities of the relevant privately owned businesses have been transferred within 24 months preceding the date of a particular transaction, the memorandum of incorporation of the private company mainly provides that the organization and its security are subject to takeover regulations.
Now we discuss the laws which are in place to protect the investors and the laws which protect the employees in the case of a merger acquisition. First, we look at the laws that are in place to protect the investors in the financial stock markets. What is the end goal of these respective laws? It is to ensure that the investors' capital is safe and that the financial market offers equal opportunities to all investors. You might ask what is in place to deter these fraudsters. The regulators tend to supply databases and clearinghouses that help to create these fair markets. The Financial Market Act 19 of 2012 and the King Report 2002 are in place to prevent malicious acts. Some additional information to make note of is the abbreviations and roles of some of the important players within the financial market as shown. In a nutshell, the National Treasury proposed guidelines to the regulatory system in South Africa and the implementation of principles like intense supervision and uniformity across regulations, to name a few. Investors and companies both profit from these laws. It helps to prevent the loss of investors' hard-earned capital, and the implementation of policies and activities help to create stability within the company. An interesting fact to look at is a study which was done by KPMG. Now into the laws which protect the employee in the case of a merger acquisition. The first question that will pop into any employer's mind would be, is my job and benefits safe? Yes, to an extent. The laws in South Africa strongly back the employees. The Companies Act of 2008, which was mentioned previously by my colleague, is very much relevant to this section because it entails the rules which the employer needs to comply with during the transfer process of an employee. Looking at Section 187 of the Labor Relations Act, primarily it ensures the fair treatment of employees along with their jobs and benefits. We mainly refer to Section 14 of the Pension Fund Act when dealing with the transfer of the employee's pension or provident fund. Within the section lies the rules which the employer needs to comply with during the transfer of the respective fund. All in all, from the seminar presentation, one should make note of the following key points. The Companies Act was created to assist with law implementation and incorporate the Bill of Rights. Auditors provide essential assurance of the firm's financial statements to users. The South African Reserve Bank and the Basel Committee help to ease the risk after a financial crisis. Trade unions help to ensure efficient functioning of legal aspects between employers and employees. Hostile takeovers are carefully and heavily regulated. Shareholders essentially and legally own part of the company. Important legal elements highlight the role that the laws and regulations play in controlling financial services. The KPMG study earlier showed just how difficult it is to recover losses due to fraud. And lastly, employees in South Africa are strongly backed by the laws, regulations, and acts within the country.